Welcome to The Explainer. Today we're unpacking one of the absolutely most stressful, high-stakes areas of Canadian family law, international relocation and custody battles. We're going to break down exactly how the legal system handles these incredibly complex disputes, and trust me, the mechanics behind these decisions are fascinating. Let's get right into it.
Picture this scenario for a second. What happens if a mother wants to take her child back to Iran after a divorce in Canada, but the father completely disagrees? He claims it's just not safe. So who does the Canadian court actually side with? It's a massive question, because one wrong legal move in a situation like this can separate a parent from their child permanently. Okay, let's dive into this. You might think one parent has an automatic advantage here, but under Canadian law, the reality is very different. Neither parent can make a unilateral choice. A mother cannot just pack up and leave with the child, and a father can't block a trip just by saying the words, "Iran is not safe." Section 1. The best interests of the child.
So, how do courts actually resolve these deadlocks? Well, under Section 37 of the Family Law Act, the court must consider the best interests of the child only. That's it. Not the parent's preferences, not their convenience. The court will ultimately rule in favor of whichever parent brings actual, solid evidence proving that their plan genuinely protects the child.
Let's break down how a judge actually assesses these best interests. They don't just guess. They use a strict statutory checklist. They are looking closely at the child's physical and psychological safety, their emotional well-being, and their absolute need for stability. If the child is old enough, their views might even be considered. And crucially, the court heavily weighs the impact of any family violence. This is the uncompromising standard judges use to evaluate any relocation plan. Section 2. The Hague Convention catch.
Applying that standard is one thing when a parent wants to move to the next town over, but it becomes incredibly complicated when relocating to a country like Iran. To understand why, we have to look at the Hague Convention. This is an international treaty signed by roughly 90 countries. Think of it as a critical safety net, providing an established legal procedure to return children who are wrongfully removed to a member state.
And this brilliantly illustrates a major catch. Iran is not a member of the Hague Convention. Plus, Canada doesn't have active consular support there. This means if a child goes to Iran and doesn't return, enforcing a Canadian court order for them to come back becomes practically impossible.
Because of this severe risk of non-return, Supreme Court of BC judges scrutinize relocation cases involving non-Hague countries with a magnifying glass. If the objecting father can provide evidence proving there's a real flight risk, the court will highly likely deny the relocation request, simply because the risk to the child's stability is too grave to ignore.
Section 3. The 60-day notice rule.
If a parent wants to relocate permanently, they can't just buy a ticket and hope for the best. Division 6 of the Family Law Act lays down some incredibly strict procedural rules. A parent who plans to relocate is legally bound to give all other guardians formal, written, advance notice of exactly 60 days.
Here's exactly how that timeline works in practice. On day 1, the relocating parent provides the formal written notice, including the exact date and the proposed location. The other guardian then has until day 30 to file a formal application objecting to the move. If no objection is filed, the move can happen, but definitely not before day 60. Now, if an objection is filed, the court steps in to rigorously weigh the reasons for the move against the profound impact it'll have on the child's relationship with the father.
Section 4. Court-imposed travel conditions. So the crucial point is, what if the trip is just short-term to a non-Hague country, but the other parent still objects? Under Section 64 of the Family Law Act, if a judge feels there's a risk, they can drop heavy conditions on the traveling parent to guarantee the child's safe return. We're talking about ordering a substantial financial bond, surrendering passports to a designated lawyer, or even an outright ban on travel without strict written consent.
Section 5. Navigating the legal crisis. As we wrap up this explainer, I really want to reiterate just how delicate this legal labyrinth is. International custody battles are literally like walking on the edge of a knife. One wrong legal move can separate you from your child permanently. The rules surrounding the Hague Convention, the 60-day notice, and proving best interests are incredibly complex and entirely unforgiving.
If you are facing this exact crisis, do not handle it alone. Contact the family law team at Pax Law Corporation in Vancouver or Toronto. You can find all of our contact details right in our bio. Make sure to subscribe and follow us for more straightforward legal insights.
I'll leave you with this final thought. If you found yourself facing a high-stakes relocation dispute tomorrow, what concrete evidence would you use to legally prove that your plan is truly in your child's best interests? It's a really tough question, but as we've seen today, in the eyes of the law, it is the only question that matters. See you in the next explainer.